Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Well, following up on Amicus Monday, we're going to talk about another amicus brief in the matter of Wolford v. Lopez. And this is what I love about very well-crafted amicus briefs. Normally, when we are challenging some horrifically unconstitutional piece of gun legislation, the petitioner's brief, well, they're kind of like the infantry. They're the foot soldiers. They got to take it head on, and you got to be very conservative with how you use your pages. You got to be very particular in the arguments you make. The amicus parties, however, well, they get to hunker down in the bushes and get to be the snipers, and you can take just about any shot you want. And so you see some very creative angles, and that's the case in the brief that we're going to be talking about today. So today, let's get you educated and let's ask this question. What if we treated the Second Amendment like the First Amendment? Okay, America, we're going to be talking about one of the many amicus briefs that was filed in a matter which is now set for oral arguments on January 20th. Of course, that is Wolford v. Lopez. There was actually 20 separate amicus briefs filed. We're going to focus on one of those today. Now, I believe it was the Beach Boys in about 1966 wrote a song called Wouldn't It Be Nice? It's a great song. And then about 1971, 1972, John Lennon wrote a song called Imagine. And it was really about what would a world be like if we could actually have things our way? Well, we're going to do something similar today because we're going to ask ourselves, wouldn't it be nice if we treated the Second Amendment just like the First Amendment? Because that's exactly the issue that is posed by the amicus brief by the good folks over at the National Association for Gun Rights, which means there is a link down below for you to show them some love, and of course by one of my favorite brief writers of all time, Mr. Barry Arrington. And sometimes I do find that if you have a person who really just doesn't understand gun laws, what you typically do is take a law, take the word gun out, put speech, put church, anything like that in there, and then they can understand just how crazy these gun laws are. The amicus brief by NAGR starts off as follows. All five of this court's recent Second Amendment precedents have noted that the Second Amendment is analogous to the First Amendment. So I want you to understand that Mr. Arrington hasn't come up with some crazy, pie-in-the-sky idea. No, actually, if we go back and we look at the five most recent significant Supreme Court cases dealing with Second Amendment issues, we will see that First Amendment analogies are routinely made. Heller, for example, has 4 separate First Amendment analogies. McDonald has 2 separate First Amendment analogies. There's one in the per curiam opinion of Catano. Bruin mentions the First Amendment 5 times, and Ibn Rahimi mentions it once. Now, as you know, in a normal world, a private property owner who holds his property open for public can exclude firearms by merely just posting a sign on there that says, hey, no guns allowed. They have the right to do that. In Hawaii, however, the state of Hawaii does that for all private property owners, and it is the owner's responsibility to actually post obvious signage if they are going to permit carrying of firearms onto their property. Mr. Arrington points out that this is a rather sticky rule, however. What does he mean by that? He means this. By sticky, legal scholars mean that individuals have a well-known tendency to stick by a default rule even when they would otherwise take a different position. Hawaii was obviously counting on the stickiness of the default rules when it enacted the vampire rule. Indeed, the Ninth Circuit admitted that the stickiness of the default rule is the only reason the vampire rule makes sense in the first place. So in essence, hey, everyone's just going to keep their mouth shut, and if everyone just keeps their mouth shut, what is the default position? The default position is everywhere on every island is basically a gun-free zone. But to understand that you actually need express written permission from a private property owner who holds his property open to the public, all we need to do to understand the absurdity of that position is just let's take gun out of it and let's talk about protected First Amendment activity. Suppose a family sits down for a meal at a fish house in Maui and the conversation turns to politics. Perhaps they want to discuss the Hawaii legislature's ongoing efforts to stifle Hawaiians' ability to exercise their right to keep and bear arms. Could the state enact a vampire rule forbidding them from discussing political topics unless they first obtain the restaurant manager's express authorization? Of course not. The very idea is absurd. Or take it to one further level of absurdity, right? Let's say the family, as they're being served, decides that they want to say grace. Do they need to get the restaurant owner's express written permission before they exercise their First Amendment right of freedom of religious expression? So in addition to the obvious Second Amendment constitutional deficiencies that this law is replete with, let us also remember that this law essentially supersedes any property owner rights, because now the state of Hawaii is making the rules for your property. As the Amicus Party points out, just as a property owner may be able to independently decide to bar invitees from carrying firearms, the Constitution poses no obstacle to a property owner establishing rules of conduct for his premises. Indeed, the Constitution specifically protects his right to do that. But the state may not presume to make the property owner's decision for them and place a thumb on the scale against the exercise of constitutional rights. And then finally, we need to dive a little bit deeper into the First Amendment. We've been able to do that recently on the channel due to other ongoing legal issues. Yes, the First Amendment does protect your ability to say whatever you want. No, the First Amendment does not protect you from the consequences of what you've chosen to say. However, here's what else the First Amendment protects you from. It protects you from having to say anything that you don't want to say. Hawaii's actual vampire rule violates the First Amendment because it constitutes impermissible compelled speech regarding a controversial political issue. This court has held time and time again that freedom of speech includes both the right to speak freely and the right to refrain from speaking at all. And so what essentially the state of Hawaii is doing is they are forcing property owners who have the audacity to want to support an individual's constitutional right to make an outward political statement for the rest of the island to see, knowing that, of course, this could be a rather controversial position, especially in a state that votes the way Hawaii does. As the Amicus Party more eloquently puts it, imagine a hypothetical private business owner in Hawaii who is enthusiastically in favor of the constitutional right to bear arms in public for self-defense. It is not difficult to imagine how that stance would be highly controversial in the state, perhaps even a minority view. If the business owner wants to allow carry on his premises, the vampire rule forces him to take a public stance on this highly controversial issue. It forces him to alert his customers that he is swimming against that cultural current. And of course, as a business owner, their primary concern would be what again? That's right, the profitability and success of their business. So are they going to keep their mouth shut in order to advance their business? Of course they will. So as we go meandering through our Constitution and we continue to look at the comparisons between Second Amendment litigation and First Amendment litigation, it is quite obvious that the Second Amendment is still the disfavored constitutional right. It is the red-headed stepchild of the Bill of Rights, leading ultimately the Amicus Party here to argue, the Ninth Circuit's reasoning makes no sense. Without the slightest doubt, Hawaii has compelled pro-public carry business owners to express their views on a controversial political topic. For the reasons set forth herein, NAGR respectfully requests the court to reverse the decision of the Ninth Circuit. Okay, that is the amicus brief from the folks over at the National Association for Gun Rights, which means, like I said before, we'll have them linked up down below. We have torn through about 6 of the amicus briefs so far. I got a lot more to go through. A very interesting one from Claremont that we're probably going to do a video on as well. Okay, the case once again is Wolford v. Lopez, brief linked up down below. If you guys got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should do around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, that information is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.